Some conservatives out there are pushing what they call a repeal amendment to the U.S. Constitution that would basically give states a veto over Washington. Here's the text of the proposed amendment. Quote, any provision of law or regulation of the United States may be repealed by the several states, and such repeal shall be effective when the legislatures of two-thirds of the several states approve resolutions for the purpose that particularly describe the same provision or provisions of law or regulation to be repealed. Republican Ken Cuccinelli is, of course, the Attorney General of Virginia. We all know him in Washington and a supporter of the amendment. Sir, you know, this reads like you don't have confidence in the federal government as such.
Well, it isn't so much that there's a universal lack of confidence as an attempt to bring back the balance of authority between the federal government and what goes on in the states. You'd have to have a pretty severe problem with one enactment for 67 or 68 state legislative bodies, because you need 2 in every state or 1 in Nebraska, to agree that something the federal government had passed was bad for America. And that's going to require bipartisan support. You can't get there with either party by itself, certainly not in the foreseeable future. And so what it's intended to do is bring back a sense of balance, because, no, we don't have universal faith in how things operate in Washington. And for a long time, the states have been and were intended to be a laboratory of democracy, and a lot of things work better in some of the states. So it's just intended to return some of the balance of power to the states.
You went to law school, so I assume you know history. And the question is, I want to know why you want to rewind the clock. We had a weak structure of states coming together under the Articles of Confederation, which, of course, you know, came out after the Declaration. And then we said, no, we're not strong enough. We need to be a country. We've got to face the world as a country, not a bunch of states to get together and agree on things, but as a country. Now it seems like you want to wind that back. You think the Constitution is too strong, as ratified in the 18th century. Is that your belief? The Constitution is too strong. It gives too much authority to the federal government.
You're dramatically overstating that. Overstating it. Of course, the Constitution was an enormous improvement over the Articles of Confederation. The Constitution is the great governing accomplishment of this country. That doesn't mean it's perfect, and it has been undone in the last 100 years to a certain degree. The Commerce Clause, on another basis of other arguments that I'm involved in, has grown massively. And we now have a federal government arguing that if you decide not to get in commerce, or if you decide to get in commerce, both of those can be regulated as commerce. That may ultimately prevail. And if that's the case, it seems very legitimate for the states to try and return in the direction. We don't get back to the kind of balance between states and the federal government that the founders put in place with the Constitution. This wouldn't even come close. This is a small step back in the direction of achieving that balance. That's all it is.
What I see here is, look, you say two-thirds of the states. Well, that could exclude the 14 most populous states, in other words, more than half the country. You could have, if I have always lived in a big state, Pennsylvania, New York, in this area here, which is a metropolitan area. If you get down to the smaller states and the plain states, you could probably come up with two-thirds of the states that wouldn't include half the country. That could easily be done. No, and it could be like some gun law or something that would appeal to the rural people.
Chris, look at your map. I mean, look at the map and think of what it would take to get to 34 states with both legislative bodies in every single one of those states agreeing that something the federal government had done should be undone. And that's the kind of hurdle that would have to be achieved. And so it creates the kind of universal concern among the states that's required to get there, which makes it a very restrained step back toward establishing, reestablishing the balance of the founders.
This is so conservative. Take a look at the states now. You've got most states, you've got some 25. Let's look at the map now. For the last map, for the next year, 25 red states are under Republican control right now. We're looking at them on the map, sir. And we're looking at another rate that are split, basically, moving toward it's been a pretty good conservative swing there. So basically, you guys have a shot. I mean, every presidential election, it seems, on average, it seems, the Republicans get most of the states because you get the rural areas of the country which are more conservative. It just seems that what you've got here is sort of a Shays rebellion, a whiskey rebellion, and you want it on paper, which is here's a way to take on the federal government. And by the way, you're bringing up the Commerce Clause. I'm a little worried here about that. What's your problem with the Commerce Clause? You got into Rand Paul country there. If you'd been on the Supreme Court back in '64, would you have given judicial review to the Civil Rights Act under the Commerce Clause?
Right, let's go back to your, yeah, we're talking about the repeal amendment first, and you talked about 25 states have Republican control. That's the high water mark as far as I know. You still need 9 other states that have split partisan control. Yeah. Even right now on what is the high water mark in state legislative control in one direction, well, in the Republican direction. It's been a lot higher in the Democrat direction over time. But you still need Democrat support, even right now, if this were the law now. So you are going to have bipartisan support. We had that in Virginia with respect to the health care Freedom Act passed last session. We have a Democrat Senate here in Virginia, and they supported the effort to put Virginia in a position to defend itself on that.
You know who's going to like this? The old Johnny Rebs are going to love that. This is antebellum. It seems to me you don't really feel yourself 100% a citizen of the country. You like to feel yourself a little more a citizen of Virginia. Like Virginia's like somehow a different country, or these states are all different countries. Well, I've lived in a number of states. I don't feel like I'm a Pennsylvania in the sense it's different. Well, because you're pushing an argument here, but you're denying the argument. You're making a challenge to federal authority here, and you're making it sound like some procedural change.
No, you're stating assumptions in your questions that presume answers that aren't correct. There's no question that insofar as you say that this would give states an ability to challenge certain acts of the federal government, you're absolutely correct in that respect. Does it undo our constitutional structure?
Veto.
Absolutely not. Absolutely not. It's completely consistent with consistent with the initial goals the founders set, and it doesn't get us anywhere near the division of authority that existed early on in this country between the federal and state governments.
Back to the point of this Commerce Clause. You know, Rand Paul was out there saying the Commerce Clause was overextended in terms of judicial review of the Civil Rights Act. Do you agree with that?
I'm not entirely sure what he said. I remember that was a controversy.
Well, let me ask you a simple question. Is the Commerce Clause sufficient grounds? Is the Commerce Clause sufficient grounds for the civil rights bill?
Anybody, if somebody's engaging in business that affects interstate commerce, which is just about everybody, it's hard to imagine not doing that anymore, then yes, it's regulatable under the Commerce Clause. And we do that. And in Virginia, obviously, more than most places, we have a history where we need to be concerned about that.
Why'd you bring it up then?
And a lot of other people are still in Virginia.
But you brought up you had a problem with the Commerce Clause the way it was used. Tell me where.
Oh, well, it is so expansive. I mean, let's take the health care litigation example. What the federal government is saying is that the decision of someone not to buy health insurance should qualify for regulation as commerce the same way that buying something in commerce does. Well, if not participating in commerce and participating in commerce are both regulatable, there's nothing left that the federal government can't reach. There's no government of limited power anymore.
This is going to appeal to the Civil War buffs.
Government was supposed to be.
This is going to appeal to the Civil War buffs from the South who love this stuff. You're really playing to the nullification crowd, it seems to be here, sir.
Oh,
I know you're
this
arguing.
Is not nullification.
You're playing to those people here.
Nullification is when a state. Hey, the nullification is when a state doesn't like what the federal government does and folds its arm and says, well, we're not going to play ball, and doesn't enact it. That is not what's going on here. This is being done in the process the Constitution provides for. Article 5 was put there in part so the states would have an opportunity to make these kinds of adjustments.
Okay, thank you so much. Attorney General of the State of Virginia, the Commonwealth of Virginia, Kenneth Cuccinelli. Thank you, sir.